Okay, well, good afternoon. It's 12 noon at the OK Corral, so let's get started. Welcome to today's webinar. The title is The Driver Shortage and the Underpinning of a Mega Verdict. My name is Mike Bush. I'm going to be talking about the mega verdicts, two recent examples, and related common threads and concerns. Sandy Leshak will take over from there and talk about specific action steps a motor carrier can take to prevent being involved in a mega verdict, specifically driver profile, technology options, and program design. Before we get started, a little bit of housekeeping. If you have questions, and we do welcome questions, please type those into the chat box and we will review those questions and address them at the end of the presentation. Okay, a little bit about us and the agency, National Risk Management. We are an insurance agency. We turned the ripe old age of 26 this year, and since day one, the agency has been 100% focused on trucking. We are proud to be recognized as the top specialty broker in 2017 by Insurance Business Magazine. And finally, we understand that different motor carrier operations have different needs, and our agency has been set up accordingly. We have groups specific to owner-operators, small fleets, and large fleets. Disclaimer, typical disclaimer, we are not responsible for anything. But in all seriousness, a couple points here. This information should not be a substitute for legal advice. And secondly, we have no liability with respect to losses caused directly or indirectly by information provided in this webinar. Okay, so let's get to the content, and let's start with the Delicate Balancing Act. On one side of the scale, driver shortage. Year in, year out, driver shortage is the #1 issue in the American Transportation Research Institute, ATRI, as we all know, yearly study. Current statistics were 48,000 drivers short, and by 2024, that number is going to jump to 200,000. As projected by the American Trucking Association. Turnover rates hover around 90%. Another interesting data point, finding drivers is so tough. Read a recent commercial carrier journal article titled War for Drivers. They cited a sign-on bonus of up to $30,000. So on the other end of the scale, mega verdicts involving motor carriers. Big payouts levied against motor carriers are nothing new, unfortunately. But here's what is new, is the size and the frequency of verdicts is getting worse. A few reasons for big verdicts. #1, the claimant's playbook. They exploit skeletons in the motor carrier's closet, tap into the primitive fears of the jury. This is known as the reptile theory, which you probably heard about and I will discuss in some more detail later. #2, limited to no tort reform in the courts. And #3, medical costs continue to rise. Quick stat here, 52% of trucking liability claims are attorney represented, something I had heard recently. Candidly, I feel like that number sounds low considering you can't go a day without seeing or hearing a law firm commercial or advertisement focused on representing claimants in trucking accidents. So the point here is that motor carriers must navigate a truly delicate balancing act between hiring and training of drivers without putting themselves in a position to be the next mega verdict. So let's talk about some claims. Claim #1 was a rear-end collision, a eye-popping $101 million verdict. Facts of loss. Tractor trailer rear-ended a pickup. Other The claimant told the responding police officer that he was not injured and actually continued on with his day. However, over the coming weeks, the claimant went to some chiropractors and had some medical procedures, and ultimately this resulted in the ultimate back surgery. The soft tissue injury is always a challenge involved in claims. Following the surgery, the claimant, who had been a crane operator, unfortunately was no longer able to perform his work duties. So let's find out what happened in the process of discovery. Number one, the driver was hired outside of the company's hiring criteria. Number two, driver tested positive for various drugs. And number three, the driver signed off on training documentation for training that he never actually completed. Asked why the award was so enormous, the claimant attorney states, this company totally disregarded their policies. They had so many chances to pull the driver off the road and they never did. Claim number two is a head-on collision, $90 million verdict. Facts of loss, icy conditions. We'll talk more about that later. Driver was traveling west on Interstate 20. Other vehicle carrying a family was traveling the opposite direction on I-20, lost control, went through a grassy medium and directly into the path of the tractor. The collision tragically took the life of the 7-year-old boy and left various other family members with catastrophic injuries. Discovery on this claim. Driver, tractor driver, no citation. In fact, he was driving below the posted speed limit, didn't lose control, and ultimately brought the unit to a controlled stop after the impact. But here's where things get a little dicey. Again, company operating outside of policy. The driver was a trainee, which we know is not a regular in this industry. However, the trainer, as per the company policy, was supposed to be sitting next to the trainee at all times during operation of the motor vehicle. In this case, the trainer was asleep in the sleeper at the time of collision. Next big piece of discovery was the weather. As mentioned earlier, it was icy. Did the driver know? Did he try to pull off? Did dispatch notify him that there was ice in the area? All of these facts were brought up in the course of discovery. Ultimately, it was bad weather, and this could have been a preventable accident had the driver pulled off because of weather-related conditions. Okay, so for these two cases and other cases that we could cite, what are the common threads and concerns? Point number one, I can't emphasize this enough. Please, please know and follow your policies. If you don't, and there is an accident, you can bet that these policies will be pulled out of the files and used against you. Number 2 point, data is everywhere. You know, your equipment, from ELDs to ECMs, you can pull out overspeeds, harsh brake, harsh cornering, all sorts of vehicle usage information. Of course, the driver information and the motor carrier. A quick story on a data-related matter on how a claimant attorney helped guide a verdict. And by the way, all this information was based on what was available on the motor carrier's website. Claimant's attorney was able to identify, number 1, how many trucks the fleet had. Number 2, average rate per mile that they charged. Not sure why they posted, but they did. And number 3, average miles that they ran in a year. Simple equation. Plaintiff's attorney or claimant's attorney used that to estimate the total revenue for the motor carrier. And their assertion was, when it was discussed with the jury, why not favor the claimant? Obviously, the motor carrier can spare a few $1 million. The reality, we're all very much aware of it, there is no money to burn in trucking. But be aware, don't let the facts get in the way of a good story, as in this case. And the point number 3 is the reptile theory. The fundamental concept here used by plaintiffs' attorneys is that the reptile brain is conditioned to favor safety and survival. Claimant attorney plants a seed of doubt in the juror's mind. For example, hey, if this one policy isn't being followed, they're probably not following anything. Makes the jurors think that, oh my gosh, all trucking companies aren't safe. This one isn't safe. Therefore, my safety is at risk, leading to claims favoring the claimants. Something else that has really popped up as it relates to the reptile theory, this is no longer just exclusively used against the large motor carriers. Attorneys have found that it's a playbook that works, 100 carriers, to a few carriers. They can use the same logic for both claims, regardless of the size of the motor carrier. Motor carriers can protect themselves from mega verdicts. It's not all doomsday. However, the choice is yours. Will you stick your head in the sand or take a proactive approach? Sandy Leshak is going to take over for me and discuss the proactive approach.
Wow, those are some eye-opening verdicts, Mike. After hearing that, let's take the proactive path. We are going to focus on 3 areas: your driver profile, technology options, and insurance program design. Let's start with driver profile. None of us have a crystal ball, but there are steps you can take to bring you to the next best thing. I just read in the Transport Topics recently that Smart Drive reported drivers who speed are 3 times more likely than their non-speeding peers to practice unsafe following distance, 45% more likely to be in a near collision accident, and 2.5 times more likely to be distracted while driving. We have seen much success with some of our insureds identifying potential employment gaps by ordering PSPs. Reviewing a driver's out of service history will paint a picture as well on how safe and cautious they are behind the wheel. You want to cross-match the data to ensure it makes sense. There is a tool available to help you understand behavior traits called DISC. DISC will help you identify drivers who are safe and cautious. Matter of fact, we did a review of serious losses amongst our insureds and found a series of indicators of behavior that would lead to a large loss. If you ignore these indicators, it could lead to a serious accident. Hire for attitude. I would like to expand just for a few seconds on the DISC tool. Through DISC, you want to be able to identify those drivers that are least likely to cause an accident. Although this is really not our business, we feel it is important to have safe, cautious drivers behind the wheel. Behavior assessment measures normal behavior in 4 areas: dominant, influencing, steadiness, and cautious. DISC. A driver's natural behavior and attitude are a great predictor of their chances of causing accidents. In summary, the DISC tool helps you proactively identify cautious drivers, which lead to fewer accidents. The second point we want to talk about is technology options. If you truly embrace technology, it really could be your friend. It could protect you. Technology is all around us. A matter of fact, you can't even step out the door without someone or some device knowing where you are or where you're going. Understand that claimants can exploit the fact that data is available from your phone, your texting records, social media like Facebook or Twitter, even ELDs and ECMs. Let's start with telematics. Telematics monitors hard brakes, harsh cornering, and overspeeds. This data is used for operations to communicate with the driver, hold the driver accountable for their actions, and design remedial training. Video cameras are another mode of technology that eliminates the he said, she said. If you don't use cameras as a proactive tool, someone out there may use it against you. And lastly, online training can be useful to conduct specific training. It's cost effective, it's easily accessible for the driver on their phone or tablet. Operations and safety will work together to assign a specific training topic. The driver logs in and completes the training module, and operations can be notified that it was completed and then follow up with the driver. In summary, technology can work for you. Further, it should be used as an integration tool with safety and operations. So we have found the best carriers are the ones who integrate safety and operations. Specifically, safety monitors the driver's activity daily. For example, a telematics alert will come in. Operation contacts the driver, discusses what happened, and gets their story. Remedial training is assigned to the driver. Safety monitors driver and determines if he needs more training. You make operations as much responsible for safety as safety is. In summary, the fleet will respond with lower CSA scores, with a decrease in accidents, and with good communication flow between driver, operations, and safety. Technology and integration of safety and operations keeps you out of the courtroom and leads to fewer losses and premium stability. Let's explore the use of cameras just a little bit further. One of our insurance partners, National Interstate, recently surveyed their clients specifically about cameras. These next few slides reflect their findings and the responses. It's not uncommon to hear initial arguments against having cameras in the trucks. It's hard to keep drivers. It costs too much. It increases my claims cost. We are going to debunk these myths. Let's start with myth 1. You will lose drivers if you install cameras. Reality is, we have seen no increase in driver turnover solely due to cameras. The most I've heard from many of our clients is maybe they've lost 1 or 2 drivers. We have seen that drivers truly begin to recognize the benefits of the cameras shortly after having them installed. After all, it only takes 1 accident to prove a driver's innocence, and you find yourself wondering why you didn't install them any sooner. Myth 2, cameras are too expensive. Reality is, it has been shown that the cost of cameras have paid for themselves. Let's think about this in the contents of a claim. Mike has an example where one of our insureds recently involved in a claim where the driver had a camera in his truck.
Okay, close your eyes and if you will, follow me. Tractor trailer is entering the interstate. Cautious speed, is doing what it was supposed to be doing. Other vehicle cuts off the tractor trailer as he's entering the interstate and specifically slams on the brake. The insured vehicle, meaning the tractor trailer, hits their brakes. Fortunately, does not hit the other vehicle in front of him. However, a load of steel pipe shifts and spills onto the interstate, causing several other vehicles to be damaged. The game changer here was a camera. The camera captured everything. And when that footage was sent to the insurance company of the car that cut off the tractor, guess what happened? They paid the claims, not the insurance company of the motor carrier. You know, and it's stories like this that we hear all the time. It's just somebody, you know, one driver raises their hand and says, you know what, I'll give it a try. All it takes is one example for that driver to avoid being in a situation where they were blamed for a claim that they were not liable for. It changes everything, changes the perception. And then what we find is the other drivers line up behind that one driver and cameras are in place. So the two takeaways here, number one, cameras really tell the true story. And secondly, cameras can actually lower claim costs.
And myth 3, reality, cameras could make a claim worse if the driver is doing something wrong. The reality is, if you are at fault, cameras will help you settle the claim faster. Cameras encourage communication between driver operations and safety. It is proven to decrease frequency and severity of claims. We have seen all kinds of arguments against cameras out there. If you are not using cameras in your truck, someone outside the truck is using them against you. Our third and final action step, insurance program design. What liability limits are required? At a minimum, $750 or $1 million limits are required by the FMCSA, unless of course you're carrying bulk hazardous materials, which would require you to carry $5 million. However, it is not uncommon to increase your liability limits to meet the requirements given by others like shippers, customers, and vendors. Why should I consider higher limits? As we briefly touched on earlier, we are seeing an increase in excess verdicts. The question is $1 million really enough? How do I protect my assets? By buying excess insurance increases your liability limits, which protects your assets, as they could be liquidated to pay damages if a jury award is above your primary limits. Try doing a Google search for truck accidents and see how many truck lawyers there are out there ready to litigate. You need this coverage to defend against lawsuits that can easily erode your policy limits. In summary, 10, 15, 20 years ago, we rarely saw verdicts over $1 million. Today, it's a common occurrence. Claimant attorneys are coming for your company, so why not protect it?
Okay, so the wrap up of this presentation, mega verdicts are real. We hear about them all the time. And unfortunately, it's a reality that faces all of us in this industry. Good news is there is technology that can be your friend, and it can act as a crystal ball to a degree and predict those drivers that could be at risk of an accident. Third point here is, can't emphasize this enough, the integration of safety and operations. These teams cannot work in silos. When they work together, work with drivers, we see incredible results. So ultimately, the choice is yours. Is your fleet going to be proactive or reactive? At this time, we'd love to take some questions if there are any. Okay, so first question from Mike is, how is our dispatch team supposed to know the sections of the road that are icy at any given time? Mike, I get it. When I read that case over and over, I wondered the same thing myself. Specifically, in that circumstance, there was a weather warning that was issued. So that was the point of specific evidence that was used to say that whether it be the driver or operations or dispatch or safety should have known that the motor vehicle was in that area at that time. I'll hold on another minute or two to see if there's any additional questions. Okay, well, I think that's it. If you have any, here's another one. Does a Qualcomm fleet message suffice to warn of weather warnings? You know, I'll give my sense of this. It seems like it would be. However, you know, if you have anyone, the PUCO or DOT that you could ask that specific question, I think that would be the guidance that I would give you. Okay, so let me leave you guys with this. My information is there. Again, I'm Mike Bush, and Sandy's information is there as well. We're here in Ohio. We focus on Ohio. If you have any questions, we'd love to come out and see you or talk to you over the phone. Oh wait, there's one more question here. Do you recommend any health training / coaching? So one of the things that Sandy mentioned was video training. We've seen a lot of success in the video training as it relates to coaching, in terms of getting to drivers quickly and efficiently and proactively training in specific areas. Now that I'm thinking about this question in more detail, specific health training, nothing comes to my mind right now. I could ask some other folks to see if they've had any experience in this. That's a good question. Yeah, if that person specifically can email me, then I can respond to you with an answer on that one. Yeah, another point here, driver wellness. I'm guessing maybe that was related to the last question, coaching for driver wellness. And yeah, I get it. You know, I think a fit driver is a happier driver and probably a more alert driver. I can dig up to see if we can find any information on that. Thank you, Bob. Agree, Bob. Okay, well, again, thank you everyone for attending. Thank you to the OTA for organizing this webinar. And we look forward to talking with you if you have any more specific questions. All right, go get some lunch. Take care.